Oh yay, oh yay, oh yay. The Honorable Court of Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the Court of Appeals. We appreciate you being here this morning, probably more so than you appreciate being here. Before we call the docket and begin our proceedings this morning, I want to take just a few moments and talk about our procedure. I'm certain that everybody here is experienced and been here before, so consequently, this is probably not necessary, but I still feel the need to do it. Each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, you may reserve that rebuttal time by, after you've introduced yourself, requesting it from the court. You may reserve up to 5 minutes of rebuttal time. Appellee gets no rebuttal time. In order to keep up with your time, we have a monitor on the podium, has a lighting system on it. The lighting system we think is very straightforward. Light will turn green once you begin your argument. As long as the light's green, you've got plenty of time. Light will turn yellow, that means you're running out of time. And when the light turns red, you're out of time. We ask that you please respect those time constraints as we go through this process. Very important thing that all attorneys, parties should be aware of. These arguments are being live streamed, which means once you say it, it's out there in front of everybody. So think about what you're saying before you say it, because there's no way we can stop it once it's been said. And it happens immediately. Before we begin the argument, I want to take the opportunity to introduce your panel for this morning. We have Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Ms. Angie, anything before we take up the first case?
No, Your Honor.
You may call the first case, please.
Kerry Wright versus John Doe et al.
Yes, sir, please. Good morning.
Good morning, Your Honors. I'm Albert McLean. I'm here on behalf of the appellant, Travelers Insurance Company, the uninsured motorist carrier. I would like to reserve 4 minutes of rebuttal time.
All right, sir. You may proceed.
As Your Honors know, this is a case involving a granting of a summary judgment by the trial court on behalf of the appellees, the tow truck company, and the tow truck driver, Choice Towing and Raul Valenzuela. We submit that the court improvidently granted the summary judgment. The court based the summary judgment on the grounds that there was not sufficient admissible evidence to allow a jury to find that the tow truck driver's acts or omissions was the cause of the accident. We submit, Your Honors, that the deposition excerpts presented to the trial court included admissible evidence regarding the issue of causation, creating a genuine issue of material fact. We have quoted a number of excerpts from the deposition testimony that was submitted to the court, and we would submit that the following testimony, which I will quote from Amber Rust, which was submitted in terms of, in the form of copies of excerpts from her deposition to the trial court. These are the questions and answers taken from the record, her deposition, which are found in the record at pages volume 3, 317 through 319. Question, do you know specifically what caused the Dodge to cross multiple lanes and leave the roadway? Answer, this got to be really congested. I mean, cars were trying to get out of the lane closest to me to get out of the way. So, I mean, it looked like it was getting dangerous. Question, what I'm interested in finding out is what specifically you saw. So, did you see specifically another car interfering with the forward progress of the Dodge, that's the John Doe driver, or forcing it off the road? Answer, I saw lots of cars that were having to avoid hitting one another because they were moving in different directions, trying to, like I said, traffic had gotten pretty heavy. So yeah, it seemed to me as if the John Doe driver was trying to avoid hitting another vehicle. Question, no ma'am.
Is that evidence? It seemed to me.
I think it would be evidence, Your Honor. I believe it's her observation based on her actual seeing of the vehicles while the accident was taking place.
Well, that's different than I saw this car do this.
Right.
When you're saying it seemed to me, you're trying to explain why the car did what the car did.
Yes, sir. There's also the quote that another following question. No, ma'am, whatever might have interfered with his forward movement, can you identify what specifically happened? Answer, it seemed to me, my impression was there was a car in front of him, John Doe, that he was trying to avoid. So he got from the lane that I thought he was in originally was the middle lane. And when he got into the middle lane, there were cars in front of him swapping lanes and slamming on their brakes. And then he didn't have anywhere else to go. And I would submit that testimony itself is admissible and sufficient to at least raise the issue and allow the issue to go to a jury as to whether or not there was sufficient evidence of causation of the tow truck driver.
Don't you agree, though, there's a vast difference between I saw this and the driver did this because of, my impression is the driver did this because he was trying to avoid this accident.
Yes, absolutely, there's a difference, Your Honor, but I would submit that the law allows for what a witness sees and also reasonable inferences from what the witness sees. And this would be a reasonable inference that was drawn by Ms. Rust and could be drawn by another person just from reading what she observed, because the facts are that were established were that the John Doe driver was in the middle lane. He had cars in front of him.
Is that even established?
Yeah, that was established.
I thought there was testimony that the John Doe driver was in the farthermost left lane.
There was testimony that he was in the farthest lane. There was testimony that he was in the middle lane by Ms. Rust. Ms. Rust testified that he was in the middle lane when she first saw him, and that he moved from the middle lane to the right lane because of the cars swapping lanes in the right lane and the middle lane, and that he didn't have anywhere else to go to avoid hitting the cars in front of him, so he swerved onto the emergency lane. That's what she testified to. So we would submit that with those facts and the inferences that can be drawn from those facts, there was sufficient admissible evidence of the issue of causation.
Well, how do we know? This struck me, and perhaps this isn't appropriate for discussion here because it may not have been taken up in the trial court, and you certainly tell me.
Okay.
The way I understand the placement of the vehicles is you had the wrecker, you had the disabled vehicle, and then you had the vehicle that was actually struck.
Correct.
How do you know that even if what these witnesses say is correct, that they weren't attempting to avoid the car that was actually struck as opposed to the wrecker, since you had three different vehicles there?
Well, we don't know all we do know is that the cars that were in front of him were in the middle lane and the right lane. And that.
No, I'm talking about the placement of the vehicles on the side of the road here.
Right.
At this point.
Right. Well, we don't know what he saw when he first swerved into the emergency lane, as far as at what point in time he actually saw the.
We don't know what he saw, and we don't know why he did what he did.
Well, I respectfully would submit that we don't know what he saw when he went into the emergency, but we know from Ms. Russ's testimony that he swerved to avoid hitting the cars in front of him in the middle lane and the right lane. I would submit that that is what her testimony at least allows for a jury to find. The appellee has argued that that the testimony as to.
Do you think she could actually testify to that in front of a jury?
Yes, I believe she could, Your Honor.
You think that she could say, if this case were to go to trial, that my impression or my belief was he was trying to swerve to avoid the cars?
I believe you could. I believe the reason I believe that is because I think that's a reasonable inference from what she saw. And what Rule of Evidence 701 says is, 701A says, if a witness is not testifying as an expert, the witness's testimony in the form of opinions or inferences is limited to those opinions or inferences which are, number one, rationally based on the perception of the witness, and two, helpful to a clear understanding of the witness's testimony or the determination of a fact and issue. And I would submit that what she testified to was rational based on her perception of what she saw, and is also helpful to a clear understanding of her testimony, and also is helpful to a determination of a fact and issue. So under that rule, which was in place since 1996, a lay witness can testify about an inference or an opinion based on what they observed. So I would submit that that would be admissible testimony, Your Honor. I would submit that, in a nutshell, the testimony offered by Ms. Russ established that the position of the choice towing tow truck partially obstructed the outside lane of I-240 and caused traffic to become congested, disrupted, and chaotic, and that when the John Doe driver was in the middle lane, the vehicles in front of the John Doe driver were swapping lanes in the right and middle lanes, slamming on their brakes, and in order to avoid hitting the vehicles in front of him, the John Doe driver she testified this, the John Doe driver had nowhere else to go other than the emergency lane, which resulted in the John Doe driver colliding with the Wright vehicle parked in the emergency lane. I would submit that under the principles applicable to motion for summary judgment, the court did not view the evidence and all reasonable inferences therefrom in a light most favorable to the non-moving party, and failed to discard all countervailing evidence as required by Tennessee law.
Let me ask you,
Yes,
is there any dispute about whether or not the tow truck was obstructing that right lane on the expressway?
There is no dispute about that, Your Honor. In fact, I think the trial court noted in its ruling that there was no dispute that the tow truck was partially in the right lane of traffic. And there was no dispute among any of the witnesses that the result of that tow truck being partially in the right lane of traffic was causing traffic in the right lane to stop and merge into the middle lane, and that there were cars in front of the John Doe driver that were slamming on their brakes and swapping lanes. And according to Ms. Rust, What she observed was the John Doe driver did not have anywhere else to go to avoid hitting the cars or vehicles in front of him other than the emergency lane.
Is there any proof in the record concerning how much time elapsed between the time that the tow truck blocked the lane and this collision occurring?
I don't know the answer to that, Your Honor. I don't know if there is evidence of that. I think I wasn't involved in the case until recently, but I don't know the answer to that particular question, Your Honor. I don't think there is, but I don't know.
Now, you refer to it as being the emergency lane, but actually it's the shoulder of the roadway.
It is a shoulder.
No driver.
It is the shoulder. Some people refer to it as emergency lane, but it is a shoulder that is on the right-hand, there's a shoulder on the right-hand side of the interstate, which is where the accident took place.
And the disabled car and Mr. Wright's car were both on the shoulder of the roadway.
That is
not blocking the right lane as a tow truck was. Is that right?
That is correct. That's true. That's true.
All right, so you've used your time.
I've used your time. Okay. Thank you, Your Honors. Appreciate it.
Good morning, Your Honor.
Good morning.
Charles Wyrick. I represent Raul Valenzuela and Choice Towing in this matter. Your Honors, you all seem somewhat familiar with the facts, but just a short recitation of what happened. On April 11th of 2018, the girlfriend of plaintiff's son, a lady named Amber Rust, had a car malfunction on I-240. Her wheel came off. She pulled over onto the right shoulder, as we've already discussed, of the road, and she called plaintiff and his son. So the plaintiff drove to where Ms. Rust had stopped her car. He parked behind her on the shoulder. The placement of the cars, which Judge Stafford mentioned, is correct, okay? So her disabled vehicle was there, plaintiff parked behind that, and eventually Mr. Valenzuela showed up with the tow truck. He pulled in front of Ms. Rust's disabled vehicle. The tow truck was 20 to 40 feet ahead of plaintiff's vehicle. It was indeed parked in a manner so that a small portion of it protruded into that right-hand lane of traffic. The interstate at that location is flat.
Were there photographs of this?
There were.
Are they in the record?
I tried to pull up my copy of the record last night for that very issue, and it was corrupted. So I apologize, but I can't answer that question. I believe that there were photographs that were presented by one of the other parties at summary judgment, but unfortunately I couldn't access the record to confirm that.
But there's no
dispute
about
There's no dispute that at least a portion of that vehicle was protruding into the right-hand lane of traffic, and there are 3 lanes of traffic northbound on I-240 at that location. So as Mr. Valenzuela was preparing to put Ms. Rust's vehicle onto the tow truck, the John Doe vehicle arrived on the scene. He originated in the far left lane. That comes from Kerry Wright Jr., the plaintiff's son. He said he was in the far left lane. Ms. Rust was a little more equivocal about it. She knew it wasn't in the right lane. He was either in the center or the far left lane. But at that point, John Doe crosses the middle lane, crosses through the right-hand lane, leaves the roadway, and then strikes plaintiff's vehicle on the shoulder. So this action was then filed a year later in April of 2019, and after conducting considerable discovery for over 3 years, defendants moved for summary judgment and did so on the basis of the language in Wright versus Women's Care that summary judgment is appropriate if the moving party can demonstrate that the non-moving party's evidence at the summary judgment stage is insufficient to establish the non-moving party's claim. Our position is simple and straightforward. Regardless of whether the tow truck was parked in a dangerous manner, plaintiff failed to adduce competent, admissible evidence that the presence of the tow truck 20 to 40 feet ahead of plaintiff's car was a cause of the collision which injured the plaintiff. Now, before going any further, I'd like to distinguish a couple of cases that are cited in the appellant's brief. It's Fruge, spelled F-R-U-G-E, versus Doe, and Hyman versus Doe. Those are both uninsured motorist cases, but that's really where the similarity of this case ends. And those, the issue was whether there was the existence of a John Doe vehicle and whether that was a cause in fact. In In Fruge, the plaintiff relied on testimony of an officer who didn't actually see the plaintiff's vehicle swerve to avoid the John Doe, but when he arrived at the scene, there was an abandoned vehicle. It was blocking 2 or more lanes, and on that basis, the court found that there was sufficient evidence to support the existence of the John Doe vehicle and its cause. The other case cited Hindman, Hindman versus Doe, and that one the plaintiff ran into a rock that was in his lane. At trial, through his own testimony and the testimony of 3 witnesses, they were able to prove that there was a dump truck that had been parked on the side of the road on the shoulder for several days prior to this accident, that there were rocks and dirt in the back of it, and that some of the dirt was piled on the shoulder near the road. The plaintiff there even went to the trouble, though, to get an expert witness who testified how that rock, as the soil settled, could have rolled into the roadway. So those are completely inapposite to the situation here, okay? In this action, plaintiff's evidence as to the cause of the accident is limited to plaintiff and his witnesses concluding that the tow truck caused a disruption, which then caused John Doe to cross 2 or more lanes of traffic, leave the roadway, and strike plaintiff's vehicle parked on the shoulder. The testimony cited by plaintiff does not include specific details which support causation, and Judge Wagner noted that fact. In ruling from the bench, she noted that this is not a John Doe case where the witnesses say, for example, "I saw John Doe run the red light," or "We saw him cut in front of you." In one of the cases cited in our brief, Phillips versus Strange Truck Lines, the plaintiff submitted an affidavit in opposition to summary judgment that set forth what he believed had occurred. It concluded with the statement, "It appears to me that the tractor-trailer driver tried to enter the road I was traveling on without stopping." The Court of Appeals held that he is unsuccessful in his attempt to create a material fact issue. This is nothing more than the plaintiff's opinion as to what happened, or stated another way, his theory of how the collision occurred. One's opinion or theory does not create a genuine issue of material fact. Now, in this action, plaintiff's case suffers from the same flaw. I'd like to examine some of the testimony of plaintiff and his witnesses. From appellant's brief at page 10, when asked how it occurred, Ms. Russ said, there was a lot of traffic at the time. At the time there was cars in both lanes, so I'm assuming that's why he went off the road. Further testimony by her, when asked for additional details, she said it looked like it was getting dangerous. And then the next question, did you see specifically something that caused the Dodge, that's the John Doe vehicle, to leave the middle lane? The cars in front of him trying to figure out where they were going. So maybe to avoid hitting a car that was in front of him. And then some of this testimony, I think this is what Judge Stafford heard and caused him to question it. But when asked for further details, she said, it seemed to me as if he was trying to avoid hitting another vehicle. And then on page 11, whatever vehicle might have interfered with his forward movement, can you identify what specifically happened? It seemed to me, my impression was there was a car in front of him that he was trying to avoid. Later on, when Mr. Wright Jr., the son, was asked about it, he said, I believe his decision was a clear lane of traffic. Later on, he says, my opinion is the reason the brakes were locked up was because there was traffic disruption. Then finally, on page 12 of their brief, of appellant's brief, he says, no, I believe the position of the truck created a disruption in traffic. And then in our brief, and I think this is probably, this summarizes it the best, when Mr. Wright Jr. was asked about it, he said, one of his statements was, quote, and I don't know why this guy did what he did, but his brakes locked up far away. So the testimony cited by plaintiff is merely the opinion of the witnesses as to what they think happened. And we've already had some discussion on Rule 701. It says that if a witness is not testifying as expert, the witness's testimony in the form of opinions or inferences is limited to those opinions to those opinions or inferences which are rationally based on the perception of the witness and helpful to a clear understanding of the witness's testimony. For the opinion of testimony of plaintiff and his witnesses on the cause of the accident to be admissible, it must meet both criteria. And it does, because the opinions are not rational. The testimony about the cause of the collision is illogical, it's implausible, it defies reason. I mean, they have the John Doe driver traveling from the left lane as far as he could be, possibly from this disruption, across another lane, across a third lane, leaving the roadway and striking plaintiff's vehicle. If this court...
Wouldn't you have to concede that the position of the tow truck caused the disruption in the traffic? And to the extent that it did, would it then be a contributing factor to the collision?
Do we know that, though? Because isn't it just as likely that the presence of the plaintiff's vehicle on the shoulder, as well as another disabled vehicle in front of it, as well as one or more individuals outside their car on the shoulder? I mean, we just don't know that. I mean, that's the point of our whole motion. There's no proof that the tow truck's position was a cause of this accident, other than these lay witnesses' opinion, which, I would say is not proper. In fact, I would say if this court considers the opinions of plaintiff and his witnesses as the cause of the collision, it'll be tantamount to making them amateur accident reconstruction experts, because it's allowing them to just draw some inferences and then reach a conclusion that that's why John Doe did what he did. While it may be permissible for a witness to testify, for example, that he saw a car driving fast, it would not be okay for the witness to testify that the car was driving fast because the driver was probably late for work. And that's the kind of conclusions that these witnesses are reaching, and it's improper. As Judge Wagner noted, the testimony as to how the truck was a cause, in fact, of John Doe's actions is mere conjecture and speculation. If the witnesses speculate as the cause, then the jury will be called upon to speculate as well, and that's just not permissible. The speculation of three interested witnesses, lay witnesses, was the only proof as to why John Doe moved from the far left lane to the right shoulder of the interstate and crashed into plaintiff. Now,
These witnesses can say, I saw the vehicle in this lane.
yes, they could say that.
I saw the vehicle move from the lane it was in to the right.
Yes.
The lanes. And I saw the vehicle strike the plaintiff's vehicle.
But yes, that would all be permissible. What would not be permissible is for them to say, and the reason that he did that was because there was a tow truck parked on the shoulder of the road. Again, it defies logic. I mean, I think.
Could the witness say, any of the witnesses say, there was a car in front of this vehicle, and I'm going a bit far afield, I
Yes.
admit that. I saw a car in front of that vehicle, and it appeared he was trying to avoid that car when he veered to the right.
And that, if that specificity was in the record, then we'd have a different case. But that's not what happened here. Yes, I think the witness could say, and I saw a red sedan that pulled in front of him, and he had no choice but to move and leave the roadway. And that but that's not the sort of specificity we have. We just have descriptions of chaos, I think was one of the words that was used in one of the depositions, or disruption is used several times in there. But it's not permissible for them to conclude that this general condition was somehow, one, caused by the tow truck. I mean, we've got them speculating at multiple levels. They're speculating that all of this disruption was caused by the tow truck and not the other two vehicles on the side of the road or the individuals outside their vehicles on the side of the road. And then we're allowing them to speculate that John Doe's actions were a reaction to the disruption that was created. And that's just not permissible. Rule 701 doesn't allow it. And because of that, there was no credible, competent proof. Plaintiff presented no competent proof that the tow truck was a but-for cause of John Doe's erratic driving. Accordingly, the trial court was correct in granting summary judgment to Mr. Valenzuela in Choice Towing, and the trial court's ruling should be affirmed.
Can a witness attribute the chaos, as you refer to it, on the roadway to the tow truck partially being in the lane of traffic and satisfy summary judgment?
Could they?
Yes.
I don't think that they could, again, because that's making them an amateur accident reconstruction expert. I mean, they would have to draw some conclusion or offer an opinion as to why John Doe did what he did, and I just don't think that's permissible. I mean, it's undisputed that some portion of that tow truck was protruding into the right-hand lane, but we don't know that, I mean, there's no proof that John Doe was reacting to that factor, other than, again, the speculation by these witnesses. And
That's part of the undisputed facts, that the tow truck was partially in the right-hand lane. Get my
yes,
diagram right here.
Yes.
The right-hand lane. And that as a result of that, I assume you're not disputing this, that it was causing some traffic concerns.
well, I'm not conceding that, no, Your Honor, because I think that disruption could have, like I said, just been caused by the fact that
Could have been a lot of things, but
drivers looked over and they saw there were three vehicles on the side of the road, and Mr. Wright got out of his vehicle at some point. Mr. Wright Jr. got out of his vehicle. Ms. Rust was there. So you've got three individuals on the side of the road. It could have been a reaction just to the fact that, smart drivers would logically just move away from some kind of an activity like that. So we just really don't know. The proof as presented requires all of us just to speculate to what happened, and that's just not appropriate.
But it's not illogical. It's actually rational, I think, to say that if you've got some portion of a vehicle protruding into a lane, that's going to char or cause some traffic congestion.
And I'm out of time, but if I could just offer this. And if that vehicle, the John Doe vehicle, originated in the right-hand lane, okay, then I think that would be a rational conclusion. But the fact that he moved from the left to the center to the right and onto the shoulder, to me, defies logic and means that that's not really a rational inference.
No, I'm not trying to make the jump that you just made. I'm just simply saying, if we're looking at what are the undisputed facts, this is part of the undisputed facts. That
Yes.
This tow truck was partially in the right-hand lane and that traffic was congested.
I have to concede that, yes.
Okay.
Thank you, Your Honor.
Thank you.
If I'd just like to respond to a few points that were made by Appellee's counsel. Appellee's counsel referred to some of the testimony in his statements to the court, and when he got to the quote that I previously mentioned, he did not include that portion of the quote, which is, and I'm reading from page 11 of our brief, which is from the record at page 3, volume 3, 319, which was from the deposition page of Ms. Rust. And she states, as part of her answer, well, the question, I'll just go back and read the whole question. No, ma'am, whatever vehicle might have interfered with his forward movement, can you identify what specifically happened? Answer, it seemed to me, my impression was there was a car in front of him that he was trying to avoid, so he got from the lane that I thought he was in originally was the middle lane. And when he got into the middle lane, there were cars in front of him swapping lanes and slamming on their brakes, and he didn't have anywhere else to go. I mean, that's from her looking at the accident, seeing the cars slamming on the brakes, hearing the slamming on the brakes, seeing the John Doe driver, with the cars in front of him and his swerving to avoid hitting them, and he didn't have anywhere else to go. So that testimony itself, I think, satisfies the issue whether or not there's admissible evidence that the John Doe driver went onto the shoulder because of the obstruction created by the tow truck that was causing these cars to swap lanes in the middle lane.
Where does she say that the obstruction, or that the tow truck was the obstruction that caused all this, as opposed to the other vehicles and the people on the road?
Well, as part of the, let's see, there's testimony in Mrs. Russ' deposition where it says, this is on page 12 of our brief, where we refer to the record, page 304 and 317, which is taken from her excerpts. She's, oncoming traffic had to swerve to avoid colliding with a choice towing tow truck that was obstructing the outside lane of this is an undisputed fact taken from Mrs. Russ' deposition, which was stated to be the undisputed fact that we proposed, the plaintiff proposed, and its response was that oncoming traffic had to swerve to avoid colliding with the choice towing tow truck that was obstructing the outside lane of Interstate 240. That was not disputed by the appellees. And then there's other testimony that I haven't quoted from in this court today that does establish that that there was congestion. Well, the testimony I did cite by Ms. Russ does show that there was congestion as a result of the tow truck obstructing the lane. That was part of what I had quoted in my.
But don't you need an accident reconstructionist?
I would submit
to explain. Let me ask my question.
Yes,
and
I'm
I'll let you
sorry.
answer it.
Yes, sir.
To explain, though, why you got the tow truck protruding into the right-hand lane. But what the John Doe driver actually hit, though, was not the tow truck, not the car that the tow truck was called to tow away, but a car that was 20 feet or more behind. When you're talking about an obstruction that is up above or further down the road.
right.
I'm really not explaining that very well.
No, I understand exactly what you're saying. And I would submit that an accident reconstructionist would certainly be able to testify about that, but I don't think it's a necessary witness, because you have eyewitnesses who are able to testify about what they saw, which links the tow truck being in the right lane of traffic, the cars in the right lane moving into the middle lane to avoid hitting the tow truck, then cars behind those vehicles slamming on their brakes to avoid hitting cars in front of them, and then the John Doe driver being in the middle lane, not being able to avoid hitting the cars in front of him other than to go onto the shoulder, which is what the facts say in terms of based on what Mrs. Russ's testimony was. And so I would submit that an accident reconstructionist would be helpful, but I don't think it's necessary, and would submit that just based on the lay witnesses' actual observations and their inferences, which under Rule 701A they're entitled to do, if those inferences are rationally based on what they saw, which, as Your Honor said, I believe you're correct, it is rational, because if the John Doe driver has nowhere else to go other than the shoulder to avoid hitting cars in front of him, it's a rational basis to infer that he went onto the shoulder to avoid hitting the cars in front of him. And second part, it is helpful to a clear understanding of the witness's testimony. It's also helpful to a determination of a fact and issue. So under Rule 701A, that testimony is admissible. I'm not sure what case Mr. Wyrick was referring to, but since 1996, lay witnesses have been able to testify about inferences or opinions based on their what they perceived as far as facts. And so I would submit that type of testimony is admissible, and in this case we have sufficient facts about what was actually observed to infer that the John Doe driver drove onto the shoulder to avoid hitting the cars in front of him, which were stopped because of the congestion from the tow truck being in the right-hand lane of traffic.
And you've used your time.
Thank you.
Yes, sir. Thank you.
Thank you.
Thank you, counsel. We will take this matter under advisement and attempt to get you an opinion as quickly as possible. Thank you. You may be excused. You may call the next case, Miss Angie.
In re Estate of Janice